give examples of some of the statements that we complain about and that have brought us here, Malady. And Malady, those examples start from 18.1 at page 5, and they proceed all the way to page 9, which is the end of 18.11. And then lastly, my lady, we point out from paragraph 77, and we deal with each of the complainants individually. And that starts at page 77 of our heads. Sorry, paragraph 77, my lady, and it goes all the way to 104. And my lady, when one looks at the way that the complainants set out their case, each of the complainants say to your ladyship, these are the statements and this is the effect. And they try and demonstrate the consequence of those statements. And much has been said about that, my lady, because if your ladyship remembers, there's a large focus on these tweets. And there's a large criticism, so much so that your ladyship has been invited to strike out some of these tweets.
But even the large focus on the tweets is from both parties, isn't it?
Yes, my lady. But what I'm really saying to your ladyship is that there's a large focus on seeking to exclude the tweets. Perhaps let me complete the sentence. Okay. And what's being said to your ladyship is your ladyship don't consider those things. Those are irrelevant, because one must look at what's. If I understood the tweets that our learned friends point out, one should only look at what the leadership of the EFF says, and it seems to have been done in a vacuum. My lady, I'm going to take a ladyship to the evidence and point out why. But before we get there, my lady, if we can just consider other aspects of the Khumalo judgment, which we agree this judgment is of assistance to your ladyship. If we can consider, my lady, paragraphs 33 to 36, because part of the arguments that these statements are irrelevant, because it's that your ladyship should only look at harm, almost physical harm, if I understand it. Your ladyship should look at the question of harm very restrictively. But if we can look at what His Lordship Judge Southern says in this judgment. '93. My lady, it's at paragraph 93.
Page.
93, my lady. And it begins, my lady, what kind of harm does the statute envisage? Is it limited to physical harm, self-evidently in the form of some degree of violence? It says, in my view, the statute is not limited to physical harm, to the category of persons against whom the hatred is directed. It says the Intimidation Act, in any event, creates a criminal offense in section 1(1)(b), which caters for that sort of harm, although the harm contemplated in that statute can also be wider. I'm going to jump onto the next paragraph. It says, harm must be construed in the context of the statute's aim. The harm envisaged that derives from interracial hostility cannot be limited to violence alone. Sorry, maybe I use your ladyship. Okay, my lady, I don't intend to read all the paragraphs. If your ladyship could just mark, yes, my lady. I'm going to jump on to 95. It says, first is the reaction of persons who read the utterances and who are inclined to share those views and be encouraged by them to also shun, denigrate, and abuse the target groups. And in this case, it was i.e. whites being unworthy, hypocritical, racist. It cannot be gainsaid that black South Africans have a great deal of justifiable resentment regarding some of the collective past and present behavior of their white counterparts. And then it says in paragraph 96, Second, harm can arise in the form of reaction by persons from the target group. There are two forms of harm in this regard. First to experience demoralization and physiological hurt. And then it says, damaging as that kind of harm may be, it's not the harm that is triggered by incitement. And the second kind of harm, which is relevant in the context, is the harm caused by responding in kind, thereby creating a spiral of invective back and forth. And so what His Lordship does in considering harm, firstly, he doesn't adopt a narrow interpretation of harm. And what His Lordship also does is to use the wording in here, my lady, is it says, it considers harm can arise in the form of reactions from the target group. And so, my lady, what the complainants then do is that they set out, in attempting to persuade your ladyship that there is hate speech and harassment. What the complainants do in their affidavits is that they set out the statements made and the consequent harm that follows. And this is from the target group, to use His Lordship's wording. And when one talks about context, I know my learned friend makes reference to the judgment to talk about context, but it's actually a feature that comes from the act itself. So, sorry, my lady, put away the act. Because, my lady, if you look at section, I believe it's 4.3. That's 3.3.
Section
3.3 of the Act. It says any person applying or interpreting this Act must take into account the context of the dispute and the purpose of the Act. And so this feature, or this concept of context, is actually one that derives from the Act itself. The Act instructs us to consider the context. And so, my lady, if we were to then consider the context in which some of these statements or where these complaints come from, one will see, when we do that and engage in the application that our learned friends did on Section 10, that in fact we are within the realm of hate speech. And so, if we can direct our attention, my lady, to paragraph 10 and deal with the prohibition of hate speech. Section 10. And we can adopt the approach taken by our learned friends, which is to read the section in two parts. And we'll adopt the same inquiry, my lady, but in its proper context and by considering the evidence that's before your ladyship. And so, my lady, if we can go to section 10. Our learned friends point out that the first inquiry is really around the prohibited grounds, which we'll get to. And the second part of it is for your ladyship to determine whether that there are words that are published that could be reasonably construed to demonstrate a clear intention to be hurtful, harmful, or to incite harm, promote or propagate hatred. So if we can undertake that inquiry. Now, my lady, I know when dealing with A, B, C in the Act, there's a debate about whether they're to be read conjunctively or disjunctively. We've made the submissions in their head that they're to be read disjunctively, and our learned friends point to, I believe it's a Kumala judgment, and say, well, the approach there was conjunctive. But, my lady, we're not asking your ladyship to be a tiebreaker on this, because whether your ladyship reads it disjunctively or conjunctively, we would submit that we're still within section 10(1)(a). And so, my lady, if we start perhaps by looking at, it'd be convenient if we look at Annexure MM21 at page 29, my lady. 2.0. And my lady, we know that submissions have already been made in this respect, that these are tweets that followed the public address by Mr. Malema on the 20th of November. But what's said there, my lady, if we were to apply the test at section 10.1, what's said there is, Mr. Malema says, well, it's the retweet which references Mr. Malema. It says, let us attack fighters. Where we meet the enemy, we must crush the enemy. When the enemy raises its ugly head, don't hit the head, cut the head. And so, those words, my lady, and to take the wording from section 10.1, that statement, the published statement, could reasonably be construed to demonstrate a clear intention to be hurtful, to be harmful, or to incite harm. But certainly, my lady, to promote or propagate hatred. My lady, and then we can move to page 32. MM 2.4, my lady. The statement that's been quoted there is, these people, I'm mentioning them by name, you must engage with them in a civilized manner and not violently. And it says violence is for those who are empty in the head, and the EFF thrives on superior logic. And that statement, my lady, you know, it's a large part of the argument to try and mitigate the impact of the first statement that I referred your ladyship to. But let me say this about it. Firstly, our learned friends say, when one considers all of these statements, and one, I mean, my lady, I'm not going through them because your ladyship's been taken them. Yes, my lady. But what our learned friends say is that when one goes through these things, one understands that Mr. Malema was speaking metaphorically, and he had no intention to speak literally. But of course, the difficulty about that argument, is that your ladyship is required to conduct the assessment set out at 10.1, which is an objective assessment. And what your ladyship does is your ladyship looks at the words and sees whether they can be reasonably construed to demonstrate those subparagraphs. And so it doesn't help them to make an argument about it being metaphorical. But the difficulty also with this argument about it being metaphorical is they don't tell us how we're supposed to understand it. And so if it isn't, to go back to 2.1, if the message being conveyed there is not to crush the enemy or cut its ugly head, then we're not told what is the metaphorical reading that we're supposed to have or to understand. And my lady, to go back to this, if I can call it, attempt to cure the first part of the statements. The first criticism is that actually it doesn't. Because they've already published, we would submit statements which are hate speech. But if we were to consider it in its proper context, your ladyship will see that the reasonable reader, or rather, that these words, my lady, I'm going to keep going back to the wording in the Act, if I don't misplace it. is that on a reading of the entire statements, my lady, one sees that what could reasonably be construed in the circumstances was to is a demonstration to a clear intention to be hurtful, harmful, incite harm or promote or propagate hatred. And I'm speaking loosely, my lady. But what I'm simply making the point, my lady, is one of the unique features about this case is that when your ladyship conducts that legal inquiry that we're concerned with at 10.1, not only will your ladyship be conducting an inquiry about the meaning of the words, but your ladyship will be supported by, in fact, evidence, so that if your ladyship is determining whether these acts do demonstrate an intention to be hurtful or harmful, ladyship has evidence that in fact it did. And we would submit, my lady, one of the most persuasive things to determining whether words could reasonably be construed to demonstrate a clear intention to be hurtful is evidence of the fact that they were hurtful, or evidence that they in fact were harmful. And we see that, my lady, again, my lady, I'm not going through all of them, but we see that at an extra MM4, my lady, where the statements are, let's make them famous. Sorry, my copy's not as clear. The statement is, let's make them famous. Those people like hashtag Paulie, hashtag Granjeni, at Max Dupree, at Feral Hafaji, Bason, are the RDF mercenaries who are deployed to defend Pravin Gordhan. We have a mandate from CIC to deal with them decisively until they become carcasses in their brains. And we see it, my lady, once just goes to the next page, MM5. All those propaganda media houses must be burned down.
Yes, until they become carcasses in concrete.
Well, my lady, the ladyship, we would have to read as we keep saying.
Yeah, because you say section 33,
yes,
consider the context.
Yes.
So, when you are saying it's not metaphorical, what does it mean?
Well, my lady, if it's not, if it's, yes, my lady, and if it's metaphorical, then it's not for us to tell your ladyship what it is. But if we apply an objective reading of it, my lady, it's to, as it says, have carcasses in their brains, which is to be dead. If we take their words objectively, and if we're going to understand it metaphorically, then your ladyship should be told what is the metaphorical meaning to be given to them. But what ladyship wouldn't have that kind of a difficulty, perhaps at MM5, which is page 38. There's a clear statement that all media houses all propaganda media houses must be burned down. And so that's an attack, my lady. That we would submit constitutes words, because, my lady, remember your ladyship is inquiring about the definition. We would submit that can be reasonably construed to demonstrate a clear intention to be hurtful, harmful, or incite harm. Particularly, my lady, if your ladyship reads it in the context of Judge Sutherland's judgment that I'd referred your ladyship to at the beginning. And that's why, my lady, I start my argument with it, because we have to understand harm in that context. It's not in the limited extent to which our learned friends suggest. The ladyship does look at the target group and how it responds to the statements that are published. But, my lady, we can continue touching a little bit. My lady, I know your ladyship has heard this evidence, and I'm not going to spend a lot of time. We can do it, my lady, perhaps by considering Ms. Munsami's affidavit, because that seems to be a big focus of our learned friends. It's only a focus as far as the striking out is concerned. If you go to page 79, maybe, or perhaps 78, the bottom of 78. Ms. Munsami sets out the statements that were said by Mr. Malema. I won't repeat it, it's been said, my lady. But if we then go to page 79 and we understand the harm of the statement, at paragraph 27, and I'm going to go back to 26, my lady, because it's a point that our learned friends make an argument about. But at paragraph 27, Ms. Munsami says, I found the tone of Mr. Malema's address unsettling, as did other journalists who went to see. Says the atmosphere in the newsroom changed. This is the effect of the statement. I'm going to jump to 29 minutes, where that negative effect is repeated. It says the incident that afternoon has impacted negatively on me and my colleagues. My colleagues have voiced their concern about my safety. My lady, I'm going to jump to paragraph 31. Where she says, I've resorted to blocking Mr. Malema from my Twitter account to shield myself from abuse. I object to his constant reference to me as an enemy. I find his repeated comments hurtful, intimidating, making me fear for my safety. My lady, at page 32. I'm at paragraph 32, sorry, my lady. One of the consequences of Mr. Malema's election to single me out is that every time he publicly attacks me, my Twitter account is flooded with abusive and threatening tweets from his supporters, and she attaches that. And at 34, which is my last quote, my lady, a tweet that particularly distressed me was posted by an EFF supporter in response to one of my columns in which I had been critical of Mr. Malema and the EFF. It reads, can we visit journalists in their homes for evidence and motives? Same journalists should give us updates on Sanef heists. Now, my lady, in the context, that visit is obviously not a visit for afternoon tea, as my learned friend has already submitted to your ladyship. In the context, it's a visit to deal with the journalists, as we've seen from the tweets or from the statements. It's a follow-up from the statements that were made by Mr. Malema. But Malema, while I'm Ms. Munsami, what's been argued is that, well, no, the relationship is great. In fact, you look at Ms. Munsami thanked Mr. Malema for his statements, and that's reference to paragraph 26. But that kind of argument, my lady, in the context of what's stated in the paragraph, is very difficult to uphold. Because at paragraph 78, as I've already pointed to your ladyship, Ms. Munsami sets out hate speech.
But Ms. Munsami sent Mr. Malema a text thanking him for his message, paragraph 26.
Yes.
But she starts by saying Mr. Malema continued his speech by telling his supporters not to use violence against us.
Yes.
Because some of us were women.
Yes.
So read it in context.
Yes, my lady, I will.
Don't isolate. I said Mr. Malema. Let's read it in context.
I will, my lady. But the context is the build-up at paragraph 25. And what I'm saying to your ladyship is that that text comes from following a statement. And the statement by Mr. Malema can hardly be said to be collegial or one that would invite gratitude. Because the statement that we see at paragraph 25 is the one where it said, let's not leave the enemy to chance. Where we meet the enemy, we must crush the enemy. On Facebook, Twitter, social media, be there, guard the revolution. And yes, my lady, Ms. Munsami says he concluded, Mr. Malema concluded his speech by telling his supporters not to use violence against us because some of us were women. And I sent Mr. Malema a text thanking him for his message. But that doesn't suggest in the context of what was said by Ms. Msami and what she says afterwards, that there's then a cordial relationship. Because if we look at what she says at paragraph 27, the next paragraph, she says, I found the tone of Mr. Malema's address very unsettling. She says, as did other journalists. Malady?
Isn't it contradictory?
With respect, no. Because
26, you thank somebody and for his speech, then the next paragraph you found his tone very unsettling.
no, sorry. Yes, no, my lady. The statement is about the message, but because she says so, she says I sent Mr. Malema a text thanking him for his message, but the impact of Mr. Malema is then dealt with further on, and she says that I found the tone of, and I don't want to be, I found the tone of Mr. Malema's address very unsettling. And my lady, that's a theme that she continues with for the rest of the affidavit. My lady, we can touch a little bit also, my lady, on the affidavit of Ms. Paulie van Wyk. And if we look at what was said, and it really starts from paragraphs, page 118. And she talks about VBS. Now, my lady, VBS is not an issue for determination in this court. Obviously, that we don't even attempt to address the contents of our article or that entire issue. We only mention it to point to the fact that Ms. van Wyk wrote this article, and that article concerned VBS, and it was critical
So
of.
what are you saying? Are you saying that VBS is not relevant?
No, I'm not. Let me say to you the relevance of it. The relevance of it is that is that Ms. van Wyk writes an article concerning VBS, which, consistent with the other complainants, then leads to an online barrage from the followers of the of the EFF. And so the mention of VBS is not on the merits of it. It's about the fact that an article was. So it's relevant for your leadership to see the connection. That there's an article from Ms. van Wyk that is critical of the EFF, and that it results from that. And that's the extent to which it's relevant. And my lady, if we can look at paragraph 14, page 120. Where Ms. van Wyk says, in isolation, many of these tweets may seem harmless. Coupled with the requests for my home address and the threat that I'll be attacked, I submit that they take on a particularly sinister tone. For example, one EFF supporter tweeted the following: "We'll be here waiting for the breaking news when the home addresses of the entire Stratcom brigade is published." And at paragraph 15, she details similar threats. And my lady, the theme I'm trying to show to your ladyship is this connection, because we go back to what His Lordship Sutherland says. When your ladyship considers this question, one does look at the response from the target. And so the theme I'm trying to do, just at this high level, is to show your ladyship that there are these published statements and there are these responses to use His Lordship's statements from the target group. And I'll do the same, my lady, with Mr. Basson. Now, Mr. Basson, my lady, if I can take your ladyship to page 174. There's an EFF supporter that we've already mentioned in our opening address, but if we can give you the context. In paragraph 19, Mr. Basson says, on 11 December 2018, an EFF supporter, Tseko, posted on Twitter that I should be killed. The tweet referring to a video clip in which the leader of the Blackland First called for white people to be killed read as follows. But for the first time, I agree with him. We must slaughter these white animals as if they kill black Africans. Actually, we must come up with action to kill white people like Adrian Basson. And my lady, what Mr. Basson also says in his replying affidavit, because he had already intimated that he was going to report it. He says he reported it, in fact. And I'll take your ladyship to it.
Before we do that,
Yes, my lady.
this table on paragraph 19,
Yes, my lady.
the annexed is AB 25. And the affidavit says he said EFF support.
Yes.
Can you say that?
So-
Anyway, that is actually EFF supporter. Or says I'm agreeing with the first.
Sorry, ma'am, let me just get back to it because I had moved from it.
It's
Sorry.
page 173. Paragraph 19.
Yes.
It says EFF support.
Yes, if we look at AB 25,
Yeah.
which is at page 203,
Yes.
well, the photo is not so clear here, but let me answer. It's not so clear because you'll see that it's a photo that has members of the leadership. But I can answer your ladyship in this way, which because it becomes more clearer in the reply that it is in fact a member of the EFF. If I can take you there, my lady. You just move up. Sorry, if I can get to the reply. Yeah. And that's his reply, my lady, starts at page 509. And he deals with it, my lady, at paragraph 6.6. It says, regarding paragraph 9, sorry, my lady.
Paragraph 6.6.
Yes, my lady, at 510.
Yeah.
It says, regarding paragraph 96.2 of the answering affidavit, I deny that the person who threatened me is an unknown Twitter user. The person at Tseko, who has since been expelled by Twitter, is clearly identifiable as an EFF member on his Twitter and Facebook profiles. His profile picture is of him posting with EFF Secretary General Mr. Godric Gadi. Mr. Gadi also follows him on Twitter. And so, and my lady, let's, if we can continue also.
Yeah, go on.
At paragraph 6.7,
Yeah.
he says, I explicitly asked Mr. Malema on Twitter whether he would disassociate himself and rebuke Tseko for making a death threat against me. His response was an unequivocal no. But I think the response might have used different words. But he says annexes A, B, and AB1 and AB2 to this affidavit are screenshots. So what Mr. Basson says, my lady, is two things. Is firstly, you can see from the picture that this is an EFF supporter. And my lady, in the context we would submit, in the context of the statements that your ladyship has, your ladyship we would submit would see the relationship between the statements made by Mr. Tseko and by following from Mr. Malema. But more than that, my lady, more than that. No, my lady, Mr. Tseko, what we say to your ladyship, my lady, as I've said, what we say to your ladyship is that there's hate speech that comes from the EFF, the respondents, and that's carried through by their supporters. I accept Mr. Tseko invokes the statement by Mr. What's his name? By the leader of the BLF, yes. But it's in the context of furthering in support of the statements. So, my lady, remember, I keep making to your ladyship this point, that there is statements and effect. And so, although Tseko speaks to the statements of, he says, by the first time I agree, we must slaughter these white people if they kill Africans. Actually, we must come up with action to kill white people like you, Adrian Passour. The only reason, my lady, he's making reference to Adrian Passour is because there's been this attack made against Mr. Passour, not in this context by the BLF, but by Mr. Malema. And my lady, let me point to your ladyship why we say so. Because if your ladyship looks at AB1, AB2, where sorry, my lady.
Page 1 is at page 177.
Yes, well, I seem to have removed it. But what the point I'm making about those two statements is that Mr. Basson brings it to the attention of Mr. Malema that he's reported this user to the South African police and invites Mr. Malema to condemn him. Malema, I don't. Lady, there you go. So he says, just opened a criminal case of intimidation against EFF supporter. He says that in his tweet. 513 and 514. He says, just opened a criminal case of intimidation against EFF supporters, and he mentions him, for threatening to kill me. And then he says that the SA Police Service, very professional, and I will assist them in tracking down suspect. No condemnation yet from EFF. And so, it's been, in this tweet, it's been put to Mr. Malema that Tseko is a supporter. It's been put to Mr. Malema that he's just, Mr. Basson has reported Tseko for case of intimidation. And the response, Malema, I think it's a point we've already made in our opening. The response is that we won't do it. But significantly, the fact of this member, this person being a supporter of EFF is not put in issue. It's not put in issue in Mr. Malema's address, in Mr. Malema's response, because the conversation continues at page 514, Malema. And because the dispute is only limited to not condemning it. And so, my lady, going back to Mr. Basson,
him saying we won't do it, it means, in a way, he's admitting to take
He's certainly not condemning it, and he's certainly not disavowing it. He's certainly not adopting the position that they adopt to your leadership today, which is, well, we are definitely not for this thing, and we disassociate ourselves. And my lady, you'll recall it's also in the context of what Ms. Haffiji says, because she also invites him to condemn. Exactly, my lady, which is a position that's different to the one that's articulated today. Because what's being said to your ladyship today is, well, you know, we're also bothered by these things, and maybe we can find other ways to try and address this thing. But in the heat of the moment, when Mr. Person calls on the EFF to do so, they don't. And when Ms. Haffiji calls on them to do so, they don't. And then when Sanef says, let's have a meeting to try and address it, they don't. And then, my lady, we then come to this court and we put affidavits and we set out all of these complaints. And, my lady, still, my lady, the position that's been adopted before ladyship is, well, these are political journalists, and so they should take what they get. It's not what our learned friends say, which is, well, we actually must do something about this. It's suggested to your ladyship, well, this is the consequence of what you get. In fact, Mr. Malema says, it won't stop. Act differently, I believe. I'm paraphrasing.
Until you are professional.
Until you're professional. Yes, until you're professional by what the EFF considers. And of course, we understand that to be until you stop writing critically of the EFF. That's really what. Yeah. My lady, as I've indicated to your ladyship, those tweets are to be read in the context. But yes, the statement certainly says so. But it's in the context of a criticism against writing by the EFF. And it's in the context, my lady, where the EFF says these journalists are part of the defense force, Ramaphosa Defense Force. These journalists are the enemy, I think it's the word. And it's really in that context of trying to stop them from being critical of the EFF. So, my lady, I won't go through the rest of the affidavits, but let me say this, that the evidence we would submit backs the inquiry that your ladyship was undertaking. In the respect that your ladyship was clearly seen, was quite evident, and we've identified them from the various paragraphs in our heads of argument. That you have statements and that you have responses. And my lady, I've referred your ladyship to portions of affidavit where we highlight that evidence. I'm not going to belabor that point, my lady. And so, my lady, we would submit, if we apply Judge Sutherland's test of harm, and if your ladyship then goes back to the statute, and your ladyship reasonably construes those statements, your ladyship, we would submit, should find that they demonstrated a clear intention to be hurtful, harmful, or to incite harm, or promote or propagate harm. And so, my lady, that's the one inquiry under Section 10. And the second inquiry under Section 10, which your ladyship was invited to do, is to consider whether the words were based on one or more prohibited grounds. And that, of course, invites a consideration of prohibited grounds in the definition. And we have two categories, my lady. There's what we call listed and unlisted grounds. And what our learned friends say to your ladyship is that in respect of B, it's really an argument about immutability. And they say to your ladyship, well, one feature that a ground in B must have is that it must be immutable. In other words, it must be a feature that that person can't change. And it's made, the point is made to your ladyship that, well, for example, one can't change their race and one can't change their gender. But the premise we would submit is incorrect, because one can change their religion, to go back to A, my lady. So if we continue and look at the listed grants, my lady, one can change their religion, one can change their conscience, and one certainly can change their belief. But there's another difficulty, and that is His Lordship Judge Lamont in the AfriForum versus Malema judgment says in paragraph 1, says, my lady, I'll find the reference, but he says to your ladyship that those unlisted grounds are wide, and they include corporations, juristic persons, and natural persons, is what he says. And so if it's correct that those listed or unlisted grounds, or the grounds in B, would include juristic persons, then it would be difficult, my lady, to make the conclusion that there can only be a ground that has got this immutable feature. It says, my lady, it's paragraph 38, it says, it is immediately apparent that the target group is widely defined and includes natural and juristic persons and associations, as well as groupings of people and categories of people. And so it's a wide definition. And as we say, the immutability argument falls because there are other grounds that are listed that are not immutable, that can be changed. For example, as I've indicated to you, religion and conscience. And my lady, we've already addressed you on the application. I'm really just responding to arguments of the prohibited grounds. And my learned friend, Mr. Berg, has already made those points. I don't intend to do it. But another point that's made to your ladyship is that, well, if your ladyship extends it to occupation, there's a big doom and gloom that will eventuate, because we don't want politicians to start attending court and litigating because there's now this extended or enlarged prohibited ground. Well, my lady, firstly, it hasn't stopped politicians from litigating. There's a number of matters that have come to court. So if a concern is to address the number of court cases, well then, my lady, that's perhaps something that's already arisen. But if that does happen, my lady, whatever politician that comes to court will have to undertake an inquiry in terms of Section 10. And so before we even get to the question of a prohibited ground, we would have to meet, or in considering, I suppose, we would have to meet the definition of hate speech in Section 10. Because, my lady, if the statements that hypothetical politician complains of constitute hate speech, then we would submit. Of course, we afforded the protection of the Equality Act. And then, my lady, that leads me to this argument about political rhetoric. My lady, I mean, our learner friends have made the point, but there is a recognition, I think it's in the ANC versus DA thing, that there's a robust debate between politicians, and that's not the issue that we quarrel with. The point is simply this, that even this political rhetoric is not unrestrained. Because of course, for example, there's an electoral act which limits it, and there's the law of defamation which limits it. And in this instance, we would submit, there's the Equality Act which limits it. And so that if this political rhetoric amounts to hate speech and amounts to harassment, then, my lady, we would submit, your ladyship should invoke the powers of the Equality Act. And then, my lady, on the point of harassment, if I understood our learned friends correctly, the argument is that it doesn't apply because the only prohibited ground your ladyship is required to, well, the only prohibited ground that would apply is the one mentioned in A and not B. And so after undertaking an interpretation of the prohibited ground, what's said is that when your ladyship then interprets prohibited ground under harassment, your ladyship gives it a different meaning. But, my lady, the prohibited ground that's referred to in that section can only be the prohibited ground that's defined and which includes the listed and unlisted grounds, my lady, if I can speak. So which includes A and B. And, my lady, again, as I've indicated, we've addressed this question of harassment in our heads of argument, and we've addressed it a lot. I don't intend to re-argue it. But simply to make this, as far as this issue is concerned, we would submit, my lady, that the evidence we've presented to your ladyship, the evidence that's before your ladyship, demonstrates harassment as prohibited in section 11, and hate speeches as prohibited in section 10. And then we say to your ladyship that on that basis, your ladyship, we would request your ladyship to grant the and interdicting these unlawful acts, if I can call them that, my lady. And of course, that appears in Annex B of our papers. So that's the relief sought at page 8. But, my lady, if your ladyship is of the view that although there is harassment, and although there is some harm, it's not a harm that falls squarely within the Equality Act, we pointed out to your ladyship an approach that's adopted by the Constitutional Court and the Supreme Court of Appeal. And that appears at page 44 of our hits, my lady. And if I can quote it, my lady, where we make reference at 44.1 to the SCA judgment, where we say, in Minister of Environmental Affairs and Tourism versus George, the court dealt with the jurisdictions of the High Court and the Equality Court and held that given that the problem of concurrency will inevitably recur, the most productive and expeditious way of achieving efficiency would seem to lie in the matter being referred to the same High Court judge who, in his capacity, or her capacity in this relationship, as an equality judge, is presiding in that court. And that's what we say to your ladyship. We say, if your ladyship is of the view that this is a matter that ought to have been taken to the High Court because it doesn't get to the reach of the equality courts, then your ladyship, we would submit, should consider it wearing your High Court hat. And, my lady, that judgment was referred to by the Constitutional Court, and And we refer that to at paragraph 44.2, which is the DeLange versus Methodist Church case, where the court considered the approach suggested by George and said, in George it was held that equality court proceedings and constitutional challenge proceedings may be consolidated for hearing before a simple judge sitting as equality court and as high court. There is indeed much to be said for this approach of permitting consolidation of disparate claims before a high court. The consolidation will not only serve the procedural requirement of the Unfair Discrimination Act, but will avoid piecemeal litigation and costs. And it's that attempt to avoid a piecemeal litigation and costs that we say to ladyship, we invite your ladyship to then, speaking loosely as to where your ladyship's high court hat. Maybe I can't say the name of this judgment, it's Wozitska, my lady, where the court made this order. It says, this court therefore makes the following order. The application is referred to a single judge sitting both as an equality court under the Promotion of Equality Court and Prevention of Unfair Discrimination Act and as a high court. Pending final determination of the application, the respondent is directed to remove or cause the removal, and it speaks to all issues around interim interdict. But simply that in that matter, the court specifically referred the matter to a judge wearing two caps. And my lady, this is consistent, we would submit with. My lady, it's at paragraph 141. Oh, what's your point? And my lady, this is consistent with the provisions of this act, my lady, because it's not correct, we would submit, but the consequence of a matter not being properly before the equality court is that it should be dismissed. Because when your ladyship, my lady, that's his paragraph, section 20 of the act, 23. Because one of the things that your ladyship is empowered to do when a complaint is brought before your ladyship is to consider whether it's properly before the Equality Court, and if it's not, to refer it to the appropriate bodies. And so if your ladyship considers that, well, this is not the kind of complaint that ought to have been brought before the Equality Court, and it ought to have been considered by a high court proper because it doesn't meet, for example, the definition of sections 10 and 11, then in referring it to an appropriate body which we would submit would be a high court, your ladyship can wear those two hats. Do you have a full set? My lady, I'm going to move on to the point about Sanef's authority. What Sanef says, my lady, is that, well, and it's dealt in the founding affidavit, in Ms. Matlatsi's founding affidavit and replying affidavit. But what's said to your ladyship, is that MANCOM is, according to the Constitution, MANCOM is the appropriate body to institute these proceedings, and that's why there's that resolution that's attached to the founding papers. Now, my lady, if we were to understand the minutes of the council's meeting, because what's been suggested is that the council sought to ratify a deficiency in MANCOM, but that's not correct, my lady. Firstly, these minutes are minutes of meeting before the respondents even answered these papers, because you can clearly see that they're on the 9th of February. My lady, it's at page 494 of the replying affidavit. So in the sequence of events, they couldn't have been brought about by this application, because we see at page 494 that these are minutes of 9 February 2019. And if you go to page 496, my lady, where this item is dealt with, what's recorded there, my lady, is that the decision to explore legal action against the EFF that was taken at our last council meeting in November 2018 was taken forward by Mancom. The case is now proceeding in the Equality Court and a judge has been allocated. And the significance of that item or that recordal is that whether your ladyship says, well, I'm not sure that Mancom necessarily has the authority. One certainly sees that even the council records that Mancom was mandated. And so, your ladyship will recall from the constitution of Sanef that you really have the council and Mancom being the structures, as it were, under Sanef. And so both structures record an authority to institute these proceedings. But to try and, the argument that's raised by our learned friends is firstly to direct your ladyship, and my lady, that's this constitution appears at page 485.
Yeah, clause 2, where they say the forum.
Yes, my lady, it's clause 3 actually. They say, well, let's look at clause 3, my lady, because clause 3, we can see from the heading, is that it's concerned with recording the legal personality and status of the forum. And as with, and the features that are identified there are features that one finds often in voluntary associations. And it says, my lady, that I'm going to go to the relevant parts of it, which appears from the third, fourth line. And it says that of entering into legal transactions and of being sued, of suing and being sued in its own name. Now, my lady, when one reads this constitution further on, the forum only meets once a year. So the forum really is the shareholders. And if I were to put it in the context of company law. So the forum really meets once a year in an AGM. It'd be a very strange thing for this organization to reserve the right to institute proceedings or to even defend proceedings to a meeting that happens at an AGM. Particularly where there are these two structures that deal with the day-to-day and give effect to the constitution of Sanef. It'd be a very strange thing, my lady, because for our learned friends to be correct, it would mean that Sanef cannot, let's put aside being suer, Sanef cannot enter into legal transactions until it waits for an AGM. Sanef, if it's sued and there's an urgent application, can't take a decision to defend that matter until it leads to until there's an AGM. My lady, if that's the constitution of Sanef, that would be very paralyzing to the business of Sanef, in fact to the management, to achieve its purpose. But this section doesn't say to your ladyship that it's only the forum that makes the decision. It simply says that Sanef, as a voluntary association, has got the right of suing and being sued in its own name. That's all it says. It says nothing, my lady, about how that's to be giving effect. And your ladyship's directed to section 5 at 486, where the powers of the forum are dealt with. But that section also doesn't say what our learned friends say. It certainly doesn't say to your ladyship that only the forum can sue or can institute proceedings, in fact, is the real issue. And so the sections that they refer your ladyship to don't say firstly what they say. But if they did, they would come to a very absurd consequence. It would really be paralyzing. It would mean that there are two structures that are created to manage the affairs of Sanef, but that they can't. So every time there's legal transactions to be concluded or to be entered into, those have to await an AGM. It'd be a very paralyzing way to conduct its business.
What about page 488, paragraph 7, structure?
Yes, it says
First sentence.
the primary and most senior decision-making body shall be members of the forum at the annual general meeting. Yes, my lady, but my lady, that's not the, one doesn't take from there that because only that the most senior decision-making body is only the forum, that then ManCom doesn't have its own competence to institute proceedings. Because, my lady, if we look at paragraph 7.15, the management committee is given, it says that the management committee will be responsible for the implementation of the policy and for the administration of the forum as referred by the Editors' Council. Then it says the management committee shall report on the activities and financial and other affairs of the forum at the annual general meeting of the forum. And then it sets out the thing. And so ManCom is given the power to implement the policy and to administer Sanef. And so if there's that power, my lady, but that power means that they can't conclude an agreement with the photocopy company, so that there's a printer in the office, my lady, it would be a very strange thing, because that's a legal transaction which they've entered into. Or if there's that power, but they're sued by a party and there's an urgent application that's pending before court, but ManCom can't make a decision about whether to defend that matter. That'd be a very strange situation. My lady, I'm getting to the end of my argument. My lady, the Wazaki judgment is a online publication. The reference we have is 27 JOL 39279 2017. JOL 39279 6J, and it's Wizaski versus Money. My lady, if I can get to the strikeout. My lady, if I'm correct in what I've advanced to your ladyship, about how the context of these complaints have to be considered, so that your ladyship sees the response of the target group, so that your ladyship can see the harm that follows it. If I'm correct on that approach, then we would submit that those tweets are relevant for purposes of the inquiry that your ladyship is. And my lady,
The application was not opposed. The striking out application, is that correct?
that's not correct, my lady.
The submission made by the respondent,
Yes. But that submission, my lady, is it's based on the suggestion that the complainants, and if I'll take you, my lady, if we can look at one of the affidavits to the complainants. At page 115, if we can look at perhaps Ms. Van Wyck's My lady, while I'm on this point, one of the things we say in our heads of argument, which is a big focus in our argument, and we make the point that it's right at the beginning, I'll read it now, where we say that the complainants are 5 journalists and an organization that advocates for rights and protection of journalists. They have joined together to seek a remedy from this court that will protect them and other journalists from the abuse and harassment they have endured by virtue of their work as journalists, as a result of the acts and omissions of the EFF and its leader, Mr. Malema. And then, my lady, we go, the first heading, the first topic we deal with is the question of the true nature of a complaint in the locus standi. And what we say to your ladyship there is that there are 6 complainants, and I'm reading paragraph 7. It says 6 is the respondents base their defense on the contention that the first complainant is the only complainant before court, and that the evidence of the remaining complainant is relevant only to the extent that it supports the first complainant's evidence. And we make the point that that's wrong. There's 6 complainants, and each complainant's evidence, each complainant's affidavit evidences their experience. And we also make the point, which is why I was taking your ladyship to page 116, that in paragraph 3, my lady, each complainant says that I've read the founding affidavit of Ms. Matlase on behalf of the first complainant in this matter. I align myself with the contents of the complaint, and I support the relief sought. And so I confirm the contents of the founding affidavit insofar as they relate to me. And so what's been suggested to your ladyship is that there's no link between the Ms. Matlatse's affidavit and that of the complainants, and because of that, there is no opposition. But of course, that's not correct. They've expressly said that they align themselves with the contents and that they support the relief sought. And my lady, it's a statement that's repeated again in the replying affidavit. And so that's something that's carried on. So it's not correct, my lady, that there's a disjuncture, because that submission is based essentially on that they haven't opposed, only Ms. Matlase has opposed, and therefore only Ms. Matlase has said something about it, they haven't said something about it, and therefore it's unopposed. But factually that's not correct, because the allegations are there, and you can, ladyship sees that they've aligned themselves to it. So I'm going to go back to the point I was making. To go back to my point, my lady. If the complainants are correct about what His Lordship Judge Sutherland says, and the approach and the manner in which to consider harm and to consider this evidence, then we would submit that it's relevant. And my lady, the point to be made is that what brings about this complaint, and it's a theme I think I've mentioned, what brings about this complaint, my lady, is the respondent's conduct. It's the statements that they publish. And the relevance of those tweets is to show the effect and the harm. And so we're not, in bringing about those, or presenting those tweets before your ladyship, seeking, for example, as our learned friend suggests, to hold the respondents vicariously liable. It's their own conduct, my lady. It's their own act that brings about their complaint. It's because when they publish and they make those hate speech and harassment, it results in this. And we show your ladyship that it in fact results in that harm. And then, my lady, the point we make about the inquiry, and let me start at the beginning, because I pointed to your ladyship that that this act talks about considering this matter within the context and the purpose of the act. It's a very unusual way to adjudicate the matters. Certainly, to go back to examples in our commercial sphere or law of contract, one doesn't look at the context. But this act specifically requires you to do so. And this act does more than that, my lady. At section 19, this act sets out rules and court proceedings. Or it deals with rules and court proceedings. And the section says this: except as is otherwise provided in this act, the provisions of the Magistrates Court Act and the Supreme Court Act and the rules made thereunder, as well as the rules made under the Rules Board for Courts of Law, apply with the necessary changes required by the context to the Equality Court, insofar as they relate, as these provisions relate to the following, and it lists them. And it lists, if I can call them items, A to E. And so you see a closed list, if I can call it, if I can say that. And those, the Supreme Court Act and the Magistrates Court Act and the rules for courts of law, their application is only in respect of A to E. And what our learned friends say is that, well, I mean, I'm not familiar with the judgments, but that our learned friends mentioned this morning. But they refer your ladyship, for example, to judgment of Muirtown. And they say, well, in that case, there was a special plea of jurisdiction. And we say, yes, that's correctly within 19.1, because if you look at 19.1e, one of the things that this court can consider is the question of jurisdiction. And Milady, we make the point about, which is not something I'm going to repeat, Milady, but we make the point about the fact that the ladyship is really engaged in an inquiry, and we developed that argument in our heads of argument. But simply, you have, Milady, an act which contains its own rules and court proceedings. And to show its uniqueness, Milady, if we look at page 21, and I'm in section 21. It itemizes the powers and functions of the Equality Act. Because if you look at 21.2, it says, after holding an inquiry, the court may make an appropriate order in the circumstances included. And so that's the unique feature of this court, is that it in fact sets out, and Milady, in the judgments that that are part of the bundle, point is made that it's actually a statutory court which derives its powers from the statute. But really, my lady, the answer to the strikeout is that the portions that we refer your ladyship are relevant to the inquiry. The answer to the strikeout is that your ladyship, in considering the context and the harm in which the statements that are complained of, the ladyship should, we would submit, see what is the response of the target group that follows from the published statements. But our learned friends speak of prejudice, and they say to your ladyship, well, the first complaint is that there's a trial prejudice. They say that, well, if you allow all of these tweets or all of this evidence, then we won't know what cause of action has been made out. But if the complainants don't make out a cause of action, and the answer is not to strike out parts of that evidence, to determine, firstly, whether they make out a cause of action in the Equality Act, or whether they meet the requirements of the duty date. And if that fails, if we can't even come home with that, then the lady perhaps your ladyship will think about, will make a determination that there is no relief to be granted. But the point is, that issue is not an issue that has any application in an inquiry about striking out. If the cause of action is not clear, the remedy for that is not to strike out portions of the affidavit. I think, my lady, the other point that was made is that it may well be, there's a complaint that if the statements are left, that they will result in statements that are defamatory being remaining. But, my lady, I'm not sure what are the defamatory statements. If we look at, for example, Ms. Munsami's affidavit, one of and my lady, you'll recall, my lady, I've taken your ladyship through the tweets and the effects of the statements made against Musami. And despite the fact that Musami's affidavit details the huge barrage from what we say are the supporters of the EFF, the focus of the strikeout application is concerned with what we see at page 82. Where she says, however, the events of 23 November 2018 have forced me to reconsider that decision. And she says that at approximately 6 o'clock on that day, I visited a shopping center near my house. I go there often on my way from work. I do not wish to disclose the precise location because I do not want a repetition of what happened on the day. And the point, my lady, that we made in our opening is not a question about pleading, but it's simply this. In the face of all the evidence that's been put before your ladyship, of the responses of the tweets in response to the statements made by the EFF, the fact that the respondents are unable to answer the allegation that she was confronted at a shopping center, really don't go to the core of the complaint. It's not so much, my lady, that they are irrelevant, but they're part of the context. But the inquiry that you're inviting your ladyship to engage in, which includes a consideration of the tweets, when your ladyship does that inquiry, this particular statement pales in significance. And so, my lady, the point about those statements, firstly, is that they are relevant because they speak to the harm and they speak to the effect of the statement. But secondly, they are much more, call it damning statements in the affidavit, so that your ladyship doesn't have to be too concerned with what's said at 42, certainly not for purposes of then inviting a referral to oral evidence. Because your ladyship, if the question about the oral evidence is whether there is a consequence, or there are effects to the statements, well, my lady, there are other portions of the affidavit that detail that. She deals specifically with that. My lady?
The oral evidence.
Yes.
It is conditional.
I understand it to be.
On the strikeout application, not being successful.
Yes, I understand it to be a secondary. But if the strikeout is unsuccessful, and your ladyship doesn't strike out the tweets, for example, and the statements that followed from the EFF's statements or speeches, for lack of a better word, then your ladyship will have before you a number of evidence and all of these tweets that talk to the effect or the harm that follows from the publication of statements made by the EFF. So that even if your ladyship then were to say, well, let me engage in an inquiry about the harm, and your ladyship doesn't have to refer this matter, this aspect, to oral evidence. That's what I'm saying to your ladyship, that if your ladyship looks at the effects in the context, it won't insist your ladyship in inquiring whether there's effects to a statement by interrogating what happened at a shopping center. But if I haven't made the point about vicarious liability any clearer, my lady, I'm now at the end. I'm just taking your ladyship to the relief we see. If I haven't made myself clear in this, man, I intend to do it now. We don't seek to hold the respondents vicarious liable for some other liability. It's not the acts of the followers that brings that we're saying a leadership should interdict. We accept. I mean, Mr. Boswan has referred a particular gentleman to the SAPS. What we seek, my lady, and that's quite clear from page 8, Annexure B. We seek to interdict their conduct because it's their conduct that results in online barrage. And it's their conduct that brings about the intimidation and harassment that the complainants complain of. I'm at the end, my lady. Yeah, my lady, I direct your leadership to the point, to Annexure B, on the relief we seek. And my lady, we're not as generous as our learned friends. We still persist for an order in respect of costs.
Okay, well done. Astonished.
I mean, that was a hard campaign.
Is it?